Judy, your claim is for a total of £1,674.98, and that's made up in a variety of ways. Now, just to be clear, I want to be absolutely fair. Matthew, you are absolutely right. You have a contract. And in the ordinary course of things, that contract would be absolutely sacrosanct. I'd have to look at it, and it would be my starting point in determining the extent to which Judy could recover anything from you. And in the ordinary course of events, had you acted, in my judgment, like a responsible landlord, had you not had further discussions with Judy, she would be completely unable to recover any of the money in respect of the rent. However, that's not what happened here. Judy, I'm going to go through your claim in turn. You have a claim for 1 month's rent and 1 month's deposit.
Yes.
As far as I'm concerned, you are liable to pay 1 month's rent. You signed a contract, and it seems to me that Matthew didn't rent out that property for at least another month. So to that extent, you're liable for that sum of money of £525.
I did try...
Talking! In respect of the deposit, however, it seems to me you're entitled to that money back. I hear what Matthew says, that this was not a deposit and he chose not to take that from you. But there's nothing in this contract to indicate that he waived his right to take a deposit. In fact, this contract, which I use as my starting point, makes clear on the face of it that there was a deposit taken, that there is reference to a deposit. And in the circumstances, you'd be entitled to that money back unless, as he's unable to do, Matthew could persuade me that you had damaged the property and therefore have forfeited that money. You haven't. Therefore, you're entitled as a starting point to at least half the money for the rent back. That's £525. I now move on to the rest of the property. Well, £100 for slate you've been charged. It seems to me that he is not able to charge you for that because that enhances his property, and it would be there long after you lived there. What's more, it seems to me by his own admission that it's something which is needed for the safe enjoyment of the fireplace. It's up to him to pay for it. It's certainly not in this contract. You're getting the £100 back as well. I now come on to the property. Now, you claim that Matthew or agents of Matthew damaged your property. It seems to me that you provided me sufficient evidence on balance that that's what happened. And what's more, when I questioned Matthew, he doesn't know when the property was moved back from where you lived, when you moved in very briefly, back to your previous address, whether these people damaged the property or not. So in respect of the washing machine, it seems to me that you complained immediately about it, and I'm satisfied that you made a contemporaneous complaint because in your mind it wasn't broken before it was returned to you. And therefore, I find on the balance of probabilities that Matthew, whether you broke it or not, the people you hired may have broken it. And I'm satisfied that that's the case and you're entitled to a new one, which is £249. The same is also true of the wardrobe, which is £250. And what's more, the clothes rail that you bought for £24.99, where you needed to hang up your clothes. Now, I should tell you this. You signed this. Had Matthew not accepted that he came to a collateral agreement, in other words, he said, I tell you what, you're such a nightmare, I will return the money as soon as I can rent this property to somebody else, you would be liable for a good deal more. Matthew, I turn to your counterclaim. It's dismissed. Because of what you subsequently said, you are not entitled to 4 months' rent, regardless whether you've got a written contract or not, because you entered into a new deal with Judy, which she acted upon. So therefore, it seems to me that this agreement, in terms of how much rent she owes, is vitiated. It's null and void. In addition to that, I hear what you say about the deposit. Even if that's true, whether you communicated that to your agent or not, it doesn't appear in this agreement. So on the face of it, I have to come to the finding that there was a deposit because you are under a statutory legal obligation to take a deposit and to keep it separate from both you and the tenant. In those circumstances, I dismiss your counterclaim. And the value in total of this claim is £1,149.98. That's the award of this court.
Thank you, Judy.
Judy was awarded £1,149.98 of her claim.